This is the Tea on International Arbitration with Nicole Silver and Gaela Garing-Flores. Gaela Garing-Flores and I are practitioners in the field of international arbitration, and we are both chairs of two committees of the DC Bar International Law Community. Gaela is the chair of the International Dispute Resolution Committee, and I am the chair of the International Investment and Finance Committee. This is part 2 of our podcast featuring Mark Cantor, a luminary figure in the field of international disputes. He is an international arbitrator in investment and commercial disputes and a well-known author who, among other things, literally wrote the book on damages. To find out more about his professional life and experience, please go to mark-cantor.com. So let's begin with part 2 of our podcast, discussing the intersection of international dispute law and the United States Supreme Court. The pressing issue of who decides whether a non-signatory to an arbitration agreement can enforce the arbitration agreement through equitable estoppel, the arbitral tribunal, or the court, was not at issue in GE Power v. Outokumpu. And it seems like this issue, the competence issue, will also not be before the Supreme Court in Henry Schein 2. As you well know, in just the last week or so, the court granted cert in Henry Schein, Inc., the Archer and White, Inc., on the question of whether a provision in an arbitration agreement that exempts certain claims from arbitration negates an otherwise clear and unmistakable delegation of questions of arbitrability to an arbitrator. Now, this is not the first time that these same parties have been before the Supreme Court. In January 2019, the Supreme Court in Henry Schein v. Archer unanimously held that under the FAA, a court may not decide a question of arbitrability, that is, whether an arbitration agreement applies to the particular dispute, if the parties clearly and unmistakably delegated the question to an arbitrator, even if the court believed that the argument for arbitrability was wholly groundless. Significantly, however, the court did not then express a view as to whether the particular contract at issue in the Henry Schein case delegated the arbitrability question to the arbitrator. Instead, it invited the Fifth Circuit to resolve on remand the issue of whether the parties had clearly and unmistakably agreed to delegate arbitrability to the arbitrator. And ultimately, the Fifth Circuit refused to compel arbitration. And it concluded that even though the parties had delegated at least some questions of arbitrability to the arbitrator, the agreement did not clearly and unmistakably delegate the question of arbitrability because the arbitration agreement included a provision exempting certain claims from arbitration. Henry Schein disagreed with the Circuit Court's decision and petitioned the Supreme Court once again. So with that rather long historic detour, let us return to where we began, which is that the court, in granting cert on only the precise issue of whether a provision in an arbitration agreement that exempts certain claims from arbitration negates an otherwise clear and unmistakable delegation of questions of arbitrability to an arbitrator, declined to expressly resolve the issue of whether incorporation of arbitration rules containing a competence provision satisfies the requirements set forth in First Options of Chicago v. Kaplan, which is, as I'm sure you know, a 1995 Supreme Court case, that courts decide arbitrability issues unless the parties have clearly and unmistakably agreed to have an arbitrator decide such issues. So, Mark, assuming you could follow my rather long introduction, and also assuming you agree with my characterization of the Henry Schein cases, do you think that the court's decision not to rule on the question of whether the incorporation of arbitration rules containing a competence provision provides clear and unmistakable evidence that the parties agreed to arbitrate arbitrability is significant or critical?
Nicole, that was very clear. The answer to your question is no. I do not think it is significant or critical. Of course, my friends, the reporters of the new restatement on international arbitration vehemently disagree with that point. Indeed, Professor George Berman submitted amicus briefs in Henry Schein 1 and the certiorari portion of Henry Schein 2, urging the court to take that issue and resolve it by concluding that incorporating arbitration rules with the competence provision does not satisfy the clear and unmistakable evidence requirement of first options v. Kaplan. The reason why I don't think it's significant or critical is illustrated by a Sixth Circuit Court of Appeals decision that came out just a little more than a week ago on June 17. Henry Blanton, Derek Piercing versus Domino's Pizza Franchising. In that case, a unanimous three-judge panel of the Sixth Circuit Court of Appeals concluded in a class action proceeding that, quote, every one of our sister circuits to address the question, 11 out of 12 by our count, has found that the incorporation of the AAA rules or similarly worded arbitration rules provides clear and unmistakable evidence that the parties agreed to arbitrate arbitrability. Went on to say, and the one remaining circuit, which by the way is the Seventh Circuit, has precedent suggesting it would join this consensus. Now, if the Sixth Circuit is correct in their counting on their fingers that 11 out of the 12 circuits have reached a common result and there are no dissents, it seems highly unlikely the Supreme Court will ever take that case and resolve it. If the only voices to the contrary are the reporters for the restatement, various NGOs concerned about arbitration and class actions, it seems unlikely that the court will take that issue on.
Thanks for your thoughts on Schein and the arbitrability question, Mark. I just wanted to know, how do you think the Supreme Court, the U.S. Supreme Court, of course, will ultimately decide the issue before it in Henry Schein 2? And what, if any, implications do you think this decision will have on parties who have entered into or could be affected by arbitration agreements, both in the U.S. and abroad?
I think, Gayla, without any hard evidence whatsoever, that the Supreme Court took the case for the purpose of overruling the Fifth Circuit and their decision that the matter was not arbitrable. You'll recall that in the underlying court litigation in Henry Schein, the plaintiffs had sought permanent injunctive relief as well as damages. The arbitration clause in the contract stated, quote, any dispute arising under or related to this agreement, except for actions seeking injunctive relief and disputes relating to trademarks, trade secrets, or other intellectual property of Pelton and Crane, shall be resolved by binding arbitration in accordance with the arbitration rules of the American Arbitration Association. I think that the court will compel some form of arbitration. But how the court does so is another question. One possibility is that the court would bifurcate the issue for the courts and the issue for the arbitral tribunal, rather than requiring exclusivity for one of the forums. That would be consistent with the apparent intent of the parties as stated in their arbitration clause. That may not be too troublesome when injunctive relief is the issue, such as the situation in Henry Schein. We are in the arbitration world accustomed to bifurcating for purposes of an option to go to the courts for interim injunctive relief. But these are mandatory carve-outs in the Henry Schein clause, rather than optional carve-outs, and the plaintiffs were seeking permanent injunctive relief, not interim relief. If we do bifurcate the injunctive question from the remaining questions in the dispute, there will be considerable duplication between the two forums. Candidly, the harder issue, in my view, is the second carve-out in Henry Schein for disputes related to trademarks, trade secrets, or other intellectual property, and the role of defenses in arbitration. We're all familiar with the fact that there are many patent licensing agreements where the arbitration clause contains a mandatory patent carve-out. An example that I had before me in a case a year or two ago, a dispute concerning the validity, scope, infringement, or essentiality of a patent or a patent claim shall not constitute a part of any arbitration and shall not be the subject of any discovery, testimony, or hearing in any arbitration. Now, the core of a dispute in arbitration may be a breach of contract claim under the license for non-payment of the license fee. However, disputes about patent validity and patent essentiality may be raised, whether validly or for obstructive purposes, as part of the defenses to the breach claim and also with counterclaims. That creates a really hard problem for the tribunal. It could mean that potentially real or potentially unrealistic validity and essentiality defenses could force the dispute out of arbitration and into the courts, by virtue of the carve-out that arbitrators could not even hear testimony on validity and essentiality or take account of discovery in connection with those topics. The complexities of such a carve-out in patent license disputes invites ulcers.
I've read in one of your many contributions to the cause, I've read that you believe that last week's rather historic decision by the US Supreme Court in Bostock versus Clayton County, protecting LGBTQ employees from discrimination based on their sex or sexual orientation, might also have implications for the Federal Arbitration Act. More specifically, you have opined that Justice Gorsuch's majority opinion for the Supreme Court in Bostock, describing how the court interprets statutes, actually implicates how courts will be required to interpret cases involving the Federal Arbitration Act. That's probably not the most obvious reading of the case for a lot of people. So I wonder if you could expand on this idea for our listeners.
Kayla, it is not the most obvious reading because most people don't read that decision with international arbitration in mind. One has to be a nerd to do so. I plead guilty. The portion of Justice Gorsuch's majority opinion, a 6-3 decision, describing how the court interprets statutes has significant implications for all statutes, including our little world of arbitration and the Federal Arbitration Act. Gorsuch wrote that the Supreme Court, quote, normally, unquote, interprets legislation, quote, in accord with the ordinary public meaning of its terms at the time of its enactment. And promptly after describing that approach, he cited to his own unanimous decision in New Prime Inc. versus Oliveira, an arbitration decision. You might recall that New Prime held that the exclusion under Federal Arbitration Act Section 1 from mandatory arbitration of disputes about contracts of employment of seamen, railroad employees, or any other class of workers engaged in foreign or interstate commerce picks up an independent trucking contractor relationship. And in New Prime, Justice Gorsuch made exactly the same point about how to interpret federal statutes. Now, not all of the justices agreed fully with the rigorous textual approach taken by Justice Gorsuch in New Prime. In New Prime, Justice Ginsburg, while joining in the unanimous opinion, wrote a concurring opinion putting a gloss on that textual approach. She said, words in statutes can enlarge or contract their scope, as other changes in law or in the world require their application to new instances or make old applications anachronistic. Moreover, Justice Gorsuch was careful in both the Bostock and New Prime opinions to qualify his textual interpretation approach with the quite cautious word, quote, normally, unquote. That single word might explain how he persuaded Justices Kagan, Sotomayor, and Breyer, all stalwart members of the liberal wing of the Supreme Court, to join in his opinions without qualification. How does this relate to open arbitration issues? One example. The court has not addressed the meaning of the phrase evident partiality, permitting vacatur of an arbitration award in Federal Arbitration Act Section 10A since 1968, when it did so in Commonwealth Coatings Corp. Versus Continental Casualty Co., and did so in a very divided fashion. As we all know, following the Commonwealth Coatings opinions, the U.S. Circuit Courts of Appeal have been split on the proper interpretation of that phrase. There is a split in the circuits. None of those courts of appeal, however, have followed the dissenting opinion of Justice Abe Fortas in Commonwealth Coatings. He, joined by Justice Harlan and Justice Stewart, interpreted evident partiality in accordance with its ordinary meaning. He said evident partiality means what it says, conduct, or at least an attitude or disposition, by the arbitrator favoring one party rather than the other. This case demonstrates that to rule otherwise may be a palpable injustice, since all agree that the arbitrator was innocent of either evident partiality or anything approaching it. Now, could the Supreme Court return to Justice Fortas' interpretive approach if an evident partiality case rises before the Supreme Court and the textual approach advocated by Justice Gorsuch commands a majority in that future case? Well, it's worth noting there were 4 justices that joined Justice Black's opinion in Commonwealth Cuttings. There were 2 justices who said they joined the opinion but wrote separately to set out candidly a rather different test. And it took those 2 to reach a majority. And then there were 3 in Abe Fortas's dissenting opinion. So what we have is a deeply split U.S. Supreme Court 52 years ago. Now, for those following the Ninth Circuit Court of Appeals decision in Monster Energy versus City Beverage, that is an interesting thought. You'll recall that the Ninth Circuit ordered evident partiality vacatur under the Federal Arbitration Act in circumstances where a JAMS arbitrator did not disclose his ownership interest in JAMS, nor did he disclose prior arbitrations and mediations by other JAMS neutrals involving one of the arbitration parties. Monster Energy has filed for certiorari in that case. Yesterday, June 25, the U.S. Supreme Court discussed that case in conference to decide whether or not to grant certiorari. Now, orders from a Thursday conference, June 25, will not appear until the following Monday. Moreover, often the Supreme Court will relist a cert petition in which they're potentially interested to decide its fate at another later conference. So a denial of cert in Monster Energy's evident partiality petition might be included on Monday's order list, but a potential grant of the petition might not. Moreover, relisting does not guarantee a grant of the petition. But Monster Energy does provide a platform for the court to reconsider what it has not discussed for 52 years. Moreover, there are evident partiality certiorari petitions every year before the court. So there will be case after case after case in which the court can decide whether or not it wishes to follow a textual approach to Article 10A of the Federal Arbitration Act, rather than the federal common law approach that has evolved and triggered a significant split in the circuits regarding the proper standard to determine whether evident partiality exists.
Mark, if your supposition is true that Bostock will have implications on how courts will be required to interpret cases involving the FAA, do you think that this decision will bolster or somehow thwart the court's historic and not so subtle agenda of promoting arbitration?
Well, Nicole, it can do both. If we look at the new Prime decision, Justice Gorsuch employed the same textual interpretation approach to expand the transportation workers' exclusion from mandatory arbitration to encompass independent trucking contractors. That could be seen as anti-arbitration. It narrows the number of cases that can go to arbitration. Or it could be seen as pro-arbitration because it eliminates one topic from the ongoing controversy in U.S. politics over whether arbitration goes too deeply into non-commercial disputes. In my hypothesized evident partiality dispute, the textual interpretation could be employed to narrow the circumstances in which an arbitration award could be vacated for arbitrator non-disclosure or conflicts. That could be seen as pro-arbitration by reducing the number of successful challenges to an award, or it could be seen as anti-arbitration by reinforcing the views of persons who are troubled by arbitration and identify the unaccountability of arbitrators as one of the reasons why they are troubled. So I don't think you can pigeonhole the approach quite so simply as pro or anti.
Thanks. And now I have another somewhat tea-stirring question for you. In just the past few weeks, the US Supreme Court has issued opinions that really are surprising to most Supreme Court watchers, considering how, ideologically conservative the Supreme Court is considered these days, namely the Bostock decision about LGBTQ rights, and even more recently, the decision regarding DACA. That was the Department of Homeland Security versus the Regents of the University of California decision coming out on June 18th. What would surprise you these days in terms of a US Supreme Court ruling in the area of international arbitration? And who do you think might be the greatest wild cards on the US Supreme Court in terms of issues affecting international arbitration?
Gayla, I think a future court could surprise us by reversing its willingness to employ arbitration to exclude consumer and employment arbitrations and to protect class actions in court. And that would indirectly affect international arbitration because the energy behind the political attacks on arbitration in the US are driven by those issues. I emphasized future because of my answer to your second question about wildcards. Who are the greatest wildcards? Well, let's start with some basic facts. Justice Ginsburg is 87 and often ill. Justice Breyer is 81. Justice Thomas is 72. Justice Alito is 70. That's 4 justices over 40, 2 of them well over 70. There are 3 justices who are over 60 years old. The next appointments to the court are the greatest wild cards. Who will move off the bench when, who will be president when that happens, and who will control the Senate when that happens. Changes like that might trigger the surprises I mentioned, or not.
Thanks, Mark. And I think Nicole has our final question for you today.
Yeah, Mark, first of all, thank you so much for giving us so much of your precious time. I know it's been a 2-part series that we've been blessed to have you. So we really appreciate all of your time and your thoughts and your insights. But before we let you go, this podcast is focused on Supreme Court issues. But before we let you go, we wanted to know if you had any final thoughts on issues more pressing on the international arbitration stage, and if so, what really is keeping you up at night?
Nicole, first let me thank you and Gayla for your patience with me. I appreciate your willingness to let me expound at great length, regardless of whether we have time for it or not. And I am going to impose on your patience yet again, because there is an issue that keeps me troubled, although I sleep quite well at night. Thank you. And that is the spread of the legitimacy attacks on ISDS to international commercial arbitration, the bleeding over of those attacks from investor-state disputes into international commercial arbitration. It's worth recalling, as only a nerd would, that the only amici taking Outokumpu's anti-equitable estoppel position in GE Energy Power versus Outokumpu were NGOs seeking to limit international commercial arbitration in order to protect against the possible consequences for US consumer arbitrations and class actions. Let me list a few of the ways there is potential for bleeding over. I have a list of 20 or so ago, and I know you don't have the patience for all 20. Let me just list the top 5. First, state parties in international commercial arbitration. The ICC reports that arbitrations involving states or state entities comprise about 15% of their docket, roughly 1 out of every 7 cases. All of the ISDS critiques are relevant to those cases, especially sovereignty concerns. Second, oil and gas. There is historic distrust of petroleum companies worldwide, compounded by environmental concerns such as climate change. 19% of ICC cases are energy related. 23% of the Hong Kong International Arbitration center cases are energy related. The potential for bleeding over of distrust of oil and gas companies into international commercial arbitrations is quite high. That is compounded by the lack of transparency for international commercial arbitration. For decades, members of the international arbitration community have pointed to the privacy of international commercial arbitration as one of its selling points. That is becoming a negative, not a positive, to observers outside the circle of international business. They regard transparency as a policy positive, not as a privacy issue. The fourth point is the role of third-party funding. Hedge funds are now investing in the prosecution of arbitration claims to make a profit. Obviously in ISDS, but also in international commercial arbitration. One need only look at the public filings by the handful of third-party funders who are public in order to see that international commercial arbitration disputes occupy a significant portion of their caseload. Well, that's easy to characterize as hedge funds. And indeed, here in the United States, we've just recently had a fairly obscure dispute over resolution of disputes involving insurance claims in healthcare, where one of the principal political attacks was the fact that they might advantage hedge funds that owned the kind of institutions that were handling some of these healthcare insurance issues. And then the lack of public accountability is the fifth significant issue. Again, in the arbitration world, we think it's a positive that there is only limited judicial review of arbitration. Outside our circle, that is not necessarily a positive. It is instead a troubling development as arbitration continues to grow and grow in the types of dispute it handles. Clearly, much of that is focused on consumer issues, employment issues, and class actions here in the United States. But it's very hard to find in the public conversation about arbitration a clear dividing line between those types of disputes and the broader question of arbitration. The attacks are on arbitration more generally, not on the specific aspects relating to consumer employment class action issues. I could go on and list a whole handful of other issues, but I know you've been, as I said, very patient with me, and I am grateful indeed to the DC Bar communities and to you, Nicole, and you, Gaela, for this podcast. So I thank you very much.
Thanks so much for joining us today, Mark. It's been great.
Yeah, thank you, Mark Cantor, and thanks to the DC Bar. To check out more on Mark Cantor, please go to mark-cantor.com. And this is the Tea on International Arbitration. Watch out for new episodes, and if you like this episode, please tell a friend about it and subscribe at anchor.fm/DCBarT.